No more questions? Done. Thank you. You're free to go. Thank you very much, both of you, for being here. Okay. This closes the hearing on H.R. 8373. I'd now like to welcome our witnesses to provide testimony on H.R. 8404, the Respect for Marriage Act. Representative Cicilline and I think Representative Roy. Well, why don't we begin, Mr. Cicilline, with you, and by the time you're done, hopefully Representative Roy will be here.
Thank you, Mr. Chairman. Thank you for the opportunity to testify, and I'm here to testify in strong support of the Respect for Marriage Act. I was proud to join Chairman Nadler and others in introducing this important measure and urge the committee to report it quickly to the House so we can pass it immediately. To begin, the bill corrects Congress's grievous mistake from a generation ago by repealing the so-called Defense of Marriage Act, or DOMA, a statute that enshrined discrimination against married same-sex couples into federal law. While subsequent decisions by the Supreme Court in United States v. Windsor and Obergefell v. Hodges effectively nullified DOMA, it remains officially on the books, lying in wait should the Supreme Court ever reverse course. We must get rid of it. Second, the Respect for Marriage Act clarifies the definition of marriage in federal law to ensure that for federal law purposes, valid same-sex marriages have equal status to any other valid marriages. And finally, the bill provides additional protection for marriage equality by prohibiting any person acting under color of state law from failing to give full legal effect to valid out-of-state marriages because of the sex, race, ethnicity, or national origin of either or both of the married individuals. Importantly, the bill gives the Attorney General the authority to enforce these protections and allows the harmed couple to bring a civil case against any official who violates these rights. Millions of LGBTQ+ people have married and formed families since Obergefell was decided in 2015. An estimated 2 million children are being raised by LGBTQ+ families, and kids do best when their families have the critical legal protections to care for one another. Passing the Respect for Marriage Act will guarantee these families the legal certainty they deserve. All married people, both those with kids and those without, who are building their lives together, must know that the government will respect and recognize their marriages. The American people agree that the right to same-sex marriage is settled law. According to a June 2020 Gallup poll, a record 71% of Americans support marriage equality, with majority supporting it across the political spectrum, across faiths, and in every region of the country. According to data compiled by the Public Religion Research Institute, 62% of Republicans, 77% of urban and suburban residents, and 70% of rural residents support marriage equality, as do the majorities of most religious groups. Although fundamental rights should never be based on public opinion alone, this data shows that the American people believe marriage equality is good, settled law. The Respect for Marriage Act will ensure that remains the case. The Respect for Marriage Act will protect the settled expectations of millions of Americans who have ordered their lives around the constitutional guarantee of marriage equality. To be clear, marriage equality already is the law of the land. In Obergefell and Loving v. Virginia, the key Supreme Court precedents recognizing constitutional rights to same-sex marriage and interracial marriage, respectively, are still in effect. People are worried, however, about the future, following the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization, which overturned the constitutional right to abortion, and Justice Thomas's alarming and extremist concurrence. Although Justice Alito's majority opinion expressly stated that the ruling did not impact any rights other than abortion, one of the main lessons from the Dobbs decision is that we cannot afford to be complacent about the security of our fundamental rights. We must act now to further protect marriage equality. At a hearing before the Judiciary Committee last Thursday, we heard from constitutional law scholars about how the logic of Dobbs, recognizing unenumerated rights only if they are, quote, rooted in the nation's history and tradition and implicit in the concept of ordered liberty as determined by the court's current conservative majority, could be used to challenge other rights, including marriage equality. In addition, Justice Thomas in his Dobbs concurrence expressly called on the court to reconsider all of its substantive due process cases, specifically naming Obergefell as a decision that the court should overturn. Even if you trust Justice Alito's assurance in Dobbs, it is well within our power to ensure long-term stability and certainty for families. Marriage has long been a basic liberty for people, and it's rooted in the principles of equal protection. Marriage equality, thankfully, remains constitutionally protected, and the Respect for Marriage Act simply offers an additional measure of protection for and enforcement of the Constitution's guarantee of equality for all Americans before the law. It will help ensure that there is a federal protection for marriage equality no matter what happens in the future. I urge the committee to support this important bill and urge its immediate passage, and happy to answer any questions of the committee.
Thank you very much, Mr. Roy.
I thank the chairman. My Democratic colleagues want Americans to believe that the Supreme Court at any moment is poised to overturn the opinions in Obergefell and Loving. I cannot help but be thankful that we don't have to have an ethics inquiry because of all of the space that Justice Thomas is taking up in the heads of my Democratic colleagues. He's living rent-free and not paying for that rent, but he's certainly living in the heads of my Democratic colleagues nevertheless. He wrote a concurrence. Justice Thomas wrote a concurrence. And in that concurrence, Justice Thomas wrote, after overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens of the United States protected by the 14th Amendment. In other words, he simply questioned the how. He simply questioned the how. And he did so in a concurrence. But at the same time, in the majority opinion, there are numerous specific mentions by the majority suggesting that the majority had no interest in touching those cases. In Dobbs, the court stated that Obergefell and other substantive due process precedents are, quote, inapposite to the asserted right to an abortion. And the Dobbs opinion, quote, does not undermine them in any way, unquote. Just in any case, anyone is not clear on the meaning of, quote, does not undermine them in any way. The court later reiterated that Dobbs' decision should not be, quote, misunderstood or mischaracterized to cast doubt on precedents that do not consider abortion. The court condemned the alarmist idea that Dobbs would lead to the overturning of the other cases as, quote, perhaps designed to stoke unfounded fear that our decision will imperil those other rights. And it is that unfounded fear that brings us here today. There is no threat. My colleagues are here for political messaging. We're here because it is July of an election year, and we're going to be adjourning in 2 weeks, and then inflation is at a high of the last 40 years, that inflation is at 9%, that our borders are wide open, and our Texans and the people across this country are exposed to wide open borders. You know, the median age of an American is about 38 years old, and that means that more than half the country wasn't even alive the last time that inflation was at the levels we currently see. And we're here because my Democratic colleagues have no answers to that, and so they want to strike fear in the American people. Unfounded fear, I would add. And I would note that my colleague from Rhode Island referenced the so-called Defense of Marriage Act. Well, that so-called Defense of Marriage Act was voted for by none other than President Joe Biden, Senator Patrick Leahy, Senator Patty Murray, Senator Dick Durbin, Senator Bob Menendez, Senator Chuck Schumer, Representative Steny Hoyer voted for the Defense of Marriage Act. Representative Ben Cardin, Representative Jim Clyburn, Representative Elijah Cummings, Representative Rosa DeLauro, Lloyd Doggett, my colleague from Texas, a host of others. I think we know why we're here. I think we recognize that we're here for political purposes. And I would note in closing, Mr. Chairman, that the rhetoric of codifying Obergefell or codifying Loving is not even true. The legislation put forward would do no such thing. The legislation put forward would force states to recognize marriages across state boundaries, which might be a laudable policy goal that we could debate. And I must side note, just thank my colleagues for recognizing the importance of the democratic process, that we're here as the people's representatives having a debate about policy rather than looking to the Supreme Court to make policy. Suddenly now that the court doesn't issue an opinion that my colleagues favor, but that it is noteworthy that the legislation put forward would not codify Obergefell and would not codify Loving in the clearly unlikely or unforeseeable case that the court were to take up a case and strike either of those down in the clear clamor for such a thing across the states, I say, obviously, with some degree of sarcasm. And I yield back.
Thank you very much, both of you, for your testimony. I don't have any other questions, except the fact that I would say that, to Mr. Roy, that I think that there are many people in this country, myself included, who are really quite concerned where the Supreme Court may go next. I think a lot of people, I think, were kind of lulled into some sort of comfort that they wouldn't go after Roe versus Wade, based on the fact that when these justices went for their confirmation hearings, would repeatedly kind of reassure everybody that it's all settled law, that they have no intention of trying to overturn it. And yet, clearly, I guess the best thing you could say was that they were intentionally misleading people. I think they perjured themselves, quite frankly, because I think they lied. But that's me. But then all of a sudden, they basically took a right away from people in this country, and we're seeing, what that has meant. A 10-year-old girl who was raped had to go to another state with her family to be able to not be forced to carry that pregnancy to full term. At an earlier panel, I talked about what's in the New York Times today, the miscarriages, an article today, when miscarriages collide with abortion law, some women are left bleeding and in pain by wary hospitals. So, I mean, we are just beginning to see the cruelty of what the Supreme Court did, by the way, against the overwhelming majority opinion in this country. And so when Clarence Thomas, who unfortunately sits on the Supreme Court, issues a concurring opinion like that, yeah, people take that as a signal for there to be more cases brought to the Supreme Court on this subject. And so, yeah, I think that was what brings us here today. You can say that that's politics. I can say that we're trying to protect people in this country and protect their rights. But in any event, that's why I'm here today. Mr. Cole?
Thank you very much, Mr. Chairman. Mr. Roy, did this legislation go through any committee?
Thank the ranking member for the question. No, and in fact, I was coming to D.C. today and had other meetings lined up and other activities that I had to engage in as a member of Congress, and was on the phone in my car coming into town trying to figure out what we're even talking about. I just read the bill, literally just read the bill in the hallway coming in here, and we're talking about marriage.
When you actually found out you were going to make an appearance.
Yeah, in the last, like, I don't know, an hour and a half ago or something in that zip code, and got the bill, read the bill, and we're talking about the institution of marriage. It's been around for millennia, and we're talking about constitutional law, which requires diving in and, like, refreshing the memory. Not all of us, I wish Jamie were here, not all of us are teaching classes every day. Yeah, that's right. Well, hey, Jamie. Not all of us are teaching classes every day, so you got to go dust the cobwebs off about Loving and Obergefell and Roe and the various cases. And we just got the bill dropped on us. I don't know, why aren't we going through the Judiciary Committee? Why aren't we having a debate? Why aren't we having a hearing?
Mr. Cicilline, when did you hear about the bill?
Members of the committee, I think, first were alerted about this bill. We worked on it before we left for this past weekend, so late last week. But to be clear, we just had a hearing in the Judiciary Committee where we discussed the implication of Dobbs. We discussed the importance of drafting legislation that would codify substantive due process rights that were threatened.
Did you discuss this bill?
Well, we discussed the importance of moving forward on.
So there was a copy of this bill that every member.
No, there wasn't a copy. But look. This is not any news. The notion that the Judiciary Committee is.
All due respect, this is the Rules Committee. This is not the Judiciary Committee. We are not set up to deal with this. We haven't had hearings on it. We haven't had any discussion on it. But we're going to have to make a decision on it. And it's not going to be a considered decision. It's not going to have been through some legislative process. It's going to be jammed through. It's been written probably in the Speaker's office. I would suspect. I know that's unheard of around here, that something like that could happen. But I think in this case it probably did. And, this, as Mr. Roy said, this is like the institution of marriage is a big deal. It deserves some consideration, some process. People could very well agree on this bill, quite frankly. But some discussion where people that had questions could pose them would really be in order. And why we're doing this in this kind of haste is just, it's malpractice legislatively. We could do something that none of us intend to do, with all due respect, even the proponents of the legislation, because it hasn't been tested, it hasn't been vetted, it hasn't gone through. And again, none of us on our side of, well, I don't sit on the Judiciary Committee. Actually, we do have some people that know what they're doing up here, I guess. But they'll, and I'm sure they'll ask much better questions than me. But I just, for the record, going to lay down, I think this process stinks. I think it's awful. I think it's terrible legislation. I think it creates division. I think this is nothing but a political stunt and a messaging bill. And, it's an embarrassment to the institution that we're legislating this way. And this is the second piece of legislation today that we've had like this. It hasn't gone through a single committee of jurisdiction, not had a single question on it. We got this bill an hour before this meeting. An hour. Come on. I mean, give me a break. No legislation should be treated that way. So, I don't have a lot of questions because I don't think this bill ought to be here in the first place. I think it ought to be in the Judiciary Committee, where I would listen to what my colleagues that deal with these subjects had to say, and I suspect they could probably find common bipartisan ground on this had it come up that way. But it hasn't come up that way. Thank you, Mr. Chairman. I yield back.
Mr. Promoter.
Thanks, Mr. Chair. And based on last week and this week, I'll bet you we've had more hearings on the Dobbs decision than judiciary's even thought about having, because we've had this issue in front of us now 4 times, or something similar, on the right to privacy. The freedom to be able to do travel in this country, freedom to have privacy in this country, freedom to make your own decisions in this country. I mean, that is so basic. I don't understand what needs to be studied or thought about that we can't do it here in the Rules Committee. So as much as I like my friend Mr. Cole, I disagree with him 100%. So, a couple things. And clearly, Mr. Roy, you practice law. I have a lot of choice terms I'd like to use for the particular Supreme Court that wrote that decision, but probably not a good idea. And my mom would say, if you don't have something nice to say about somebody, don't say anything, so I'm not going to say anything. But what I am going to say is, for whatever reason, you brought up, the prices of things unrelated to this particular bill, and I'm just curious if you know what the price of copper was February of this year compared to today.
I have no idea what the price of copper is today.
The price of lumber.
I mean, a pretty good idea. I do a lot of shopping for lumber, but lumber has ebbed and flowed, but it's still expensive. I mean, all goods and services are expensive.
It's half the price today
off of a massive high.
In February.
Off of a massive high.
As is copper.
And when I go buy copper to wire my house, which I did, it's expensive and a lot more expensive than when I wired my house just a few years ago. Right. Massively expensive.
Just you and I can argue about it. It's
right.
50% today as what it was in February. Same thing,
off of
lumber
a massive
and
high.
Copper. No, not off of massive high.
Have you bought chicken? Have you bought any of the food at the grocery stores that people have to live on?
I'm asking the questions.
Right. But my parents just built a house.
This is my time.
Okay, but
what about, you're from Texas?
Yeah.
You have any idea how much the price of oil, West Texas Intermediate, has dropped in the last 3 weeks?
I mean,
my question is easy to answer, yes or no. Right. Do you know what it has dropped in the last 3 weeks?
Yeah. So you're saying that the fact that it goes down off of a massive high after massive policy supply restrictions that is driving up the price of energy?
Can you answer any question, yes or no?
I am answering the question on behalf of the American people that I represent. Yeah, I mean, yeah, people are.
It has dropped.
$4 a gallon gasoline. Yay!
Yeah, it's down.
That's awesome.
Okay, down
Sell
40
that
cents.
home.
My question was, is it down?
$4?
The answer is yes.
Pat yourself on the back
Okay,
for $4.
what about the barrels? You know it's down $40 a barrel?
$4 gasoline is what you're excited about?
Did you know that it's down by $40 a barrel? I'm just.
So? What does that mean for the consumer?
Do you know it's down? If you don't, just say I don't.
I know what the price of oil is, but so what? If it doesn't help a consumer, so what?
Why don't you keep going?
Right. Well, why don't we, let's keep going. Let's open up oil and gas exploration in America.
Yeah, so we opened up. We already had this in prior panels.
Do you know how investments
work? We have double the production today that we did 15 years ago.
But do you know how investments work to go build a refinery? Do you know how investments work to go build the necessary tools to go explore and get oil? Or how about a nuclear facility, which we haven't built?
It's good to have you up here. You always get me going.
Good.
I appreciate that.
Good.
Okay. I think that what is being requested in this bill is urgent. I think that the Supreme Court did a complete about-face on so many prior decisions that the fact that Mr. Cicilline, that Dr. Schreier, that others have brought bills to this committee on a basic principle of privacy and freedom that all of us understand, doesn't need some expert opinion. We can act on this now because it is an urgent matter. It places families in jeopardy, the prior bill places doctors and women in jeopardy. So I'm going to not debate with you anymore about finances. I support the bill and I yield back.
Okay, Dr. Burgess.
Thank you, Mr. Chairman. So I filled my pickup up last night, and it cost $75.
Yeah.
Now, it might have cost $85 2 weeks ago, so maybe I was smart to delay and run it nearly to empty. But it's still a hell of a lot more than it was when gas was $2.70 a gallon.
Nobody was working.
Look, the reason gas has come down, the reason oil has come down is because capital markets see the looming recession, and they're worried. And I think they should be worried because there is a looming recession. Let me just, look, I can't say it any better than Ranking Member Cole did. I think I said it after the previous discussion. There is no reason to be doing this type of work in the Rules Committee. Again, I stress, we're the apex predators of legislation. The Judiciary Committee, the Energy and Commerce Committee is where the nuts and bolts of this sort of stuff is supposed to happen. And Mr. Roy, you're telling us that you really didn't have the opportunity to chew through this on the Judiciary Committee, you all who are the experts on the law and the writing of the law and the enforcement of the law?
Yeah, I mean, to be clear, there was no markup on this legislation. This legislation was presented to me literally today, the text of it today, as I was coming into D.C. to do other things, and then to come here before the Rules Committee to try to make the case that this is not the way to do business, that the process is terrible. Obviously, substantively, I've got significant concerns, and I think it raises lots of questions. About the role and power of the federal government, what they should do, what they shouldn't do. When you're making a claim that you're saying that you're codifying something, when in fact it's not. And again, first blush, I'm looking at it, it's not really codifying Obergefell or Loving. We ought to have a robust debate about that in the committee. We ought to have a robust debate about the role of Congress in light of what the court does or might do. It's fine. I mean, that's what we do as the people's representatives, but we're not doing that.
Well, I thank you for being here. I thank you for coming on such short notice, and I really regret the fact that we're having to hear the bill under these circumstances. Energy and Commerce Committee is going to be marking up a big privacy bill later this week, and that's the way to do things. To go through the legislative hearings, to go through the subcommittee, full committee markup. That's where we do our best work. It's a shame we're not allowed to do that in this instance. I yield back.
Mr. Raskin.
Oh, Jamie's on TV.
Thank you very much, Mr. Chairman. This is a bill about freedom and equal rights. I have to depart from my colleagues across the aisle who say that it's just a messaging bill or it's fear-mongering or whatever. In the wake of the Dobbs opinion, I think this is something that's absolutely necessary for us to do. So what's the logic of the opinion? And I would love to have a colloquy with my friend, Mr. Roy, about it if he wants to. What's the logic of the opinion? Well, here's the way I understand it. The Supreme Court says not that it's going to ban abortion or not that it's going to legalize abortion, but it's going to leave it up to the states. The people who want to ban abortion are in Congress and are in the state legislatures. The people who are passing the laws, which say no exceptions even for rape or incest. So a 10-year-old girl who's impregnated by a rapist has to carry the pregnancy to term and have the rapist child. But that's not in the Supreme Court decision. The Supreme Court just says that the Constitution is silent about abortion. And because the word abortion is not mentioned in the text of the Constitution, it's not covered by the constitutional right to privacy, which vaguely remains standing in a somewhat shaky, hobbled way. But you know what else isn't in the Constitution? The word contraception is not in the Constitution. The word marriage is not in the Constitution. And so those who've been arguing against allowing gay people to get married have been making that point for a long time, that there's nothing in the Constitution, in the text of it, which gives gay people the right to be married, just like there are those who want to ban IUDs and other forms of contraception who are saying now, echoing the Supreme Court, the word contraception doesn't appear in the Constitution. So is it really fear-mongering for us to say that with millions of children of gay couples in the country and people who want to be able to rely on the marriage sacrament and want to be able to rely on their legal documents, that we're going to protect the right to marry and we are not going to allow that to be taken away? Well, if everybody agrees that gay people have a right to be married, what's the problem with just solidifying that right in federal law? You know, I would remind my friend, Mr. Roy, and those across the aisle, Roe versus Wade was written by a Republican nominee to the Supreme Court, Harry Blackmun, who was nominated by Richard Nixon. In fact, 5 Republican justices in the majority in Roe versus Wade were nominated by Republicans. Chief Justice Warren Burger voted for Roe versus Wade. Justice Powell voted for Roe versus Wade. They were both Nixon appointees. Brennan and Stewart were Eisenhower appointees. There were only 2 Democratic nominees who voted with it. And even after that, Republican nominees to the court, like Justice Souter, a Bush nominee, or Stevens, who was Ford's nominee, they all agreed with it, that the constitutional right to privacy was sufficiently comprehensive to apply to a woman's right to make a decision about abortion. So it's not always been a partisan thing. I don't think that they should view it in partisan terms, that we want to defend the freedom of Americans to get married. What is so radical about that? Mr. Cicilline, the point was made that some of our Democratic colleagues had voted for the Defense of Marriage Act. I think Senator Schumer's name was invoked, maybe Bill Clinton's name was invoked. I happen to believe that the transformation of public opinion and political opinion about the right of everybody to get married is one of the great breakthroughs and great victories of freedom and equality in our country. Should we oppose this bill because they say that it's somehow inconsistent because Democrats once voted for the Defense of Marriage Act?
Thank you for the question. You know, both Democrats and Republicans have made statements about marriage equality, and the Democrats that Mr. Roy mentioned, all I think would be fair to describe them as having evolved, and I think are now great champions for marriage equality. As a member of the LGBTQ community, we are grateful for their support in our fight for full equality. We wish more of our Republican friends would join us in this fight. But I welcome people who think more about these issues and understand the impact on families and understand that members of the LGBTQ community are entitled to the full protection of the law and access to marriage like every other American. And, I think you look at the evolution of all of those Democrats who not only have recognized that DOMA was wrong, but have become great champions for equality for the LGBTQ plus community. I wish I could say the same of more of my Republican friends.
Well, and of course, that's the history of civil rights in America. There were Democrats and Republicans who opposed voting rights for African Americans, civil rights for African Americans, and later they come to say, well, of course, it's obvious, everybody accepts it. And that is just the nature of the human mind and neuroplasticity. It generally takes people a while to accommodate the idea of other people's equality and other people's equal freedom. Mr. Roy did make one point that I thought was good that I'd like you to respond to, Mr. Cicilline. He said that this legislation in reversing DOMA will not actually codify the right of gay people to get married. It will just require states honor marriages from other states. Is that right? And does this not go far enough in order to guarantee that gay people can get married all over the country?
Well, I think, as you know, Professor Raskin, a marriage is a institution of the state, so the federal government's role, and although Mr. Roy said it would be a laudable goal to require states to recognize the marriage of other states, it's not a laudable goal. It's the current law of this country that if you are married in one state, it must be recognized by another state. And so it will codify the right of individuals to get married and then require other states to recognize a lawful marriage that may have been performed in another state. And that's the current law. It will codify that. And while, the suggestion has been made that, the process here stinks, I would say, you know what else stinks? That millions of LGBTQ Americans are worried about the sanctity of their marriage and about the sanctity of their family. And when you talk about these inflationary concerns, those same concerns are concerns to LGBTQ people. We shouldn't layer on top of that anxiety about whether or not their marriage is going to remain legally recognized. And so, although Mr. Roy said he's not worried about marriage equality, I think he said there's no threat. That's easy for a heterosexual white man to say. I can tell you lots of people in the LGBTQ community feel very much under threat, and it's not sort of made up in their heads. You look at the decision. Justice Thomas says that he says we should reconsider all of this court's substantive due process precedents. These are precedents which, as you say, Professor Raskin, identify freedoms that the American people have, and he specifically cites Obergefell. And then he quotes himself in a bunch of cases with phrases like, after overruling these demonstrably erroneous decisions, or we have a duty to correct the error. So there's lots of good reason for members of the LGBTQ community and people who care about our community to be anxious about whether or not we will continue to have marriage equality in this country. And if Mr. Roy really is worried just about the process, I want to say to the chairman of the committee, thank you for taking this up with the urgency of the other matters relating to substantive due process. We don't have time to waste. This is an activist court, an anti-freedom court that is trying to strip away what are well-established freedoms of the American people: contraceptive, abortion care, marriage equality, and I applaud this committee for moving quickly. These aren't new issues. Versions of this bill have been introduced for many Congresses. For any member of Congress to suggest this is the first time they're really struggling with the idea of marriage equality is silly. This has been debated and thought about for a very long time. This very bill is introduced multiple times. Please don't use process to avoid addressing the serious threat to LGBTQ families that the Dobbs decision presents, and I urge you again to move quickly and pass this bill. And thank you, Mr. Raskin, for yielding to me.
Are you yielding back?
I'll just...
Oh, go ahead.
Yeah, I just want to close with one thought, Mr. Chairman, which is that the rights of the LGBTQ community are under attack all over the world. Vladimir Putin, of course, has been trampling the rights of gay people. Orban in Hungary, Pakistan, Egypt, Afghanistan, Qatar, and so on. And I suppose I would be a little more reassured by people who are saying, well, don't worry about what the Supreme Court might do if they started by saying they supported Obergefell, and if they started by saying they support the decisions protecting women's right to contraception, because politically, what I hear is they say all of that should go down. That was judicial activism. That was overreach. And then we say, okay, let's legislate, codify it. They say, oh, you're being hysterical. You're going too far. I think this Supreme Court has shown us exactly how careful we need to be. I yield back to you, Mr. Chairman.
Thank you, Mr. Reschenthaler.
Thank you, Mr. Chairman. I appreciate it. Mr. Roy, there was a lot that was discussed in that last back and forth. Do you have anything that you'd like to add?
Yeah, I think it's important. To Jamie's point, and his gracious, I'll put it, observation of saying that I made a good point, which was to raise the question about what this bill does or doesn't do when we use language like codification of Obergefell or Loving. And so that would be something that you would normally flush out in a Judiciary Committee hearing and or markup, right? Which I think would be a valuable thing to do on something so monumental and something so important as this issue, broadly speaking. But I would also just note, with respect to the point that the gentleman from Rhode Island raised about Justice Thomas's quote, which we've all heard, and I quoted a lower passage in that same quote earlier, in which he is laying out he disagrees with the how. Right? He lays out his concerns under substantive due process. Now, we can have a debate about that, and Jamie and I could have some fun at his law class and kind of have a debate about, and raise that. And fine. But he's laying out the how and that he has a concern with that. And then he articulates, that he's saying, look, we might reach a similar conclusion on the rights in question. He's arguing that that should be done under privileges and immunities or some other path. You can disagree with him on that. But I don't want us to put words in his mouth about what the conclusion would be on the rights as opposed to the how. And then the critically important part is what the majority opinion wrote. And they wrote a whole lot, and I'm not going to go through all of it. But like, for example, one part in the slip opinion 32, what sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey relies, something that both decisions acknowledged, abortion destroys what those decisions call potential life, and what the law at issue in this case regards as the life of an unborn human being. See Roe, and there's quotes, I'll skip to the next part. None of the other decisions cited by Roe and Casey involve the critical moral questions posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. I could go through 4 or 5 other large paragraphs and passages and sections, concluding in one by Justice Kavanaugh, where he says, first is the question of how this decision will affect other precedents involving issues such as contraception and marriage, in particular decisions in Griswold, Eisenstadt, Loving, and Obergefell. I emphasize what the court today states: overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. Now, again, we can have a debate about all of that. I think that the majority opinion, probably went out of its way to outline those. I think the first draft had certain quotes, and then when the concurring opinion was drafted, there were additional quotes, I think. I've not been able to go compare side by side the leaked draft and so forth, which is why that's such a dangerous and slippery slope. But anyway, I thought that's important to be in the record, and critically important as to why we should have a hearing, why we should have a markup. And we should go through this. We should have a debate on such an important issue, and frankly decide where Congress is on some of these things. And they're complicated, and there's a lot of law behind that and a lot of policy choices behind that, and we should have a robust debate about these things.
Thank you, Mr. Roy. I appreciate it. With that, I yield back.
Ms. Scanlon.
Thank you. Mr. Cicilline, you mentioned that last week there was a judiciary hearing on the impact of the Dobbs decision on, among other things, same-sex marriage. Is that right? And
yes.
If I recall correctly, it was a fairly robust and long-winded hearing?
Yes.
Okay. And we looked at, possible legislative solutions to the impact of the Dobbs decision on gay marriage, among other substantive due process rights.
That's correct.
I find it cold comfort to suggest that, it's only the Justice Thomas concurrence that says he wants to overrule Obergefell, because, of course, the author of that decision, Justice Alito, the Dobbs decision, joined with Justice Thomas just 2 years ago to say that Obergefell was wrongly decided, was abhorrent, was a problem that the court must fix. So I don't think there's any real question about where Justice Alito wants to go, even if he's willing to do a little tap dance in the Dobbs decision. Were there other lessons that you think we could bring from the hearing last week?
Yes, thank you so much for the question. The scholars that we heard from made it very clear that assertion by Justice Thomas, or that Mr. Roy just read, that, none of this applies to other stuff, was completely unsupported in the law. In fact, there's no legal basis to say the substantive due process that they found no longer existed for a woman's right to abortion care could be distinguished from a whole set of other privacy interests, whether it's contraceptive or marriage or other intimate personal decisions of individuals. So the notion that, to make the Dobbs decision apparently more palatable to people, they would give this false assurance that, oh, don't worry, none of that applies here. There's no discernible legal basis for making that distinction. There's a lot of reason that legal scholars think they have set the roadmap for stripping away many freedoms that the American people currently enjoy. We don't have to wonder. They gave us some breadcrumbs. The concurring opinion of Justice Thomas lays it out. They're coming for contraception. They're coming for marriage. They're coming from many other substantive due process sort of privacy protections. So the notion that we should, take them at their word and don't worry about it, if that's really true, then everyone should vote for this bill. If you think this is settled law and you think the Supreme Court's not going to reverse it, then vote for it. There's no harm in that. It will just secure for millions of Americans the assurance that their marriage will be legal and recognized, and they'll have equality, and they can worry about the other things in their family's life and not have to worry about their marriage. I dare say that if Mr. Roy's marriage were threatened to be declared illegal, he would be worried about it. It would weigh on him. Well, it weighs on the minds of millions of Americans who wonder, is the court going to take away this basic freedom? This bill will fix that.
Well, it also seems a rather strange time to be saying, oh, well, the court said it in an opinion, so they're not going to say something else later, when we've just seen them overturn 50 years of settled law. Thank you. I yield back.
Ms. Fishbach.
Thank you, Mr. Chair. I just have to comment. The witnesses from the last bill should feel lucky because they had 3 days to look at that bill. This one was an hour. We got it, an hour before committee started. So I just have to take the time to say, this is a trend, this is political theater, this is how the majority wants to run this place. No transparency, no committee hearings. And I hear over and over how important this is, how important this issue is on all of these, and that they should go through committee. If it's important, you should take the time to have people hear about it, listen to the testimony, listen about the bill, not just have hearings about general issues, but really hear about the bill. Have the opportunity to look at the bill, understand it, and it is not the way we should be creating laws. We should be running Congress. We should not be doing this. We should have the kinds of hearings, the kinds of process that is laid out and that the American people expect. And it's embarrassing for Congress to do this. And I just want to give Mr. Roy the opportunity to respond to anything that he may be heard or wants to add.
Well, I appreciate that, and obviously we want to move forward. I won't belabor it too much, but I think the gentlelady is correct. I've made my point on that known. I would note with respect to Roe, for example, there were legal challenges on that, probably annually from 1973 to this year. Can't remember exactly how many made it to the court and where, but there were a lot of challenges, right, over the years. I'm unaware of one that's gotten any legs in terms of the challenge with respect to Obergefell over the last, what has it been, 7 years since Obergefell? I can't remember I think 2015. Jamie's not here for me to run the years by him, but I think that says something about kind of where things are. But I also think it's important. Like the decisions here about what we're talking about, these are tough decisions, and we have strong opinions about these. I get that. When in the hearing that we talked about, the gentleman from Rhode Island, we had a witness who was actually overlapped with me at the University of Virginia, and she's now a professor. And I was asking her the question of who decides, right? Who decides when life begins, and who decides when life is worthy of protection, and how we protect it. That's a really complicated question. It's a really complicated question. And for 50 years, we acquiesced to say the court decided, and then kind of created a range. And we had Roe, and then we had Casey, and then now here we are. I think that this is indicative of some of the problem when courts come in and say, okay, here it is. You got 9 folks, and sometimes you like who those 9 are and what the decisions are making, and sometimes you don't. And they ebb and flow, obviously, with presidencies, and that changes over time. My point of bringing that up is just these are incredibly complex decisions. and we distill them down to something, and I do it too, because we're politicians, so we have to distill them down to simple sound bites and go sell them. But this is a really complicated question. When does life begin and when do you protect it? I know we're not even talking about that in this legislation because we're advancing to other issues in the, dare I say, penumbras of the core question that we're talking about here. But I think that's an important part of this. And I would note that I didn't get a really good answer, right, from the witnesses on that question. Why? Because it's hard, right? It's a difficult question. So you say, somebody said, well, the mom should decide that question. It's like, well, I mean, okay, but if the mom decides that question after what we would call the birth date at 3 months, or if the mom decides that question a week before the birth date, and we don't go down that road and debate all the policy on that. We would normally do that in judiciary. But I think that's a really important part of this entire conversation.
Thank you very much. And, I do want to add, we talked a little bit about prices earlier. And I think if we were really, really wanting to address what is weighing heavy on Americans' minds is $8.35 box of Lucky Charms. I bought that. That's what's weighing on families' minds, is because that's serious things that they are buying off the grocery stores and that making it more and more difficult for them to feed their family every day. That's the kinds of things that we should be dealing with and we should be trying to address here. So thank you very much, and I yield back.
Mr. Morelli.
Thanks, Mr. Chairman. Given how remarkable the chairman of this committee and the ranking member are, if we were the only committee function in Congress and every bill came to us, I'd be okay with that. I think we'd do a pretty good job, but not. Well, the ratios are kind of good.
If the gentleman would yield, if I were on rules, I would think the same thing. But.
I'm sure. Look, I appreciate this. The bill is not lengthy. I read through it when it was printed. I think we all, as Mr. Cicilline has indicated, have had long opinions about the subject. I know that I voted for marriage equality in New York when I was a member of the New York State Assembly back in 2007, 2009, and then we finally enacted it in 2011. Given what we believe, at least on our side, about this issue, this seems to me entirely appropriate. We've talked a lot about the opinion in Dobbs and Justice Thomas's concurring opinion on this subject, and I agree with you, Mr. Cicilline, that millions of Americans have every right to be more than troubled about this and wondering what this means for their relationships, their families. This isn't just a theoretical exercise. I mean, this is really goes to the heart of what those relationships and those families are all about. And frankly, even the notion that, and I'd say this, that, given what Justice Thomas wrote, all the assurances notwithstanding, I mean, as I've said a number of times and others have said, Justice Kavanaugh said that in his in the proceedings related to his confirmation, said that it was settled law in Roe, and he clearly didn't believe that when it came time to cast his vote. So I'm not sure we could take anyone's assurances at this point. But honestly, on some level, that doesn't even matter. What does matter is Article 1 of the Constitution gives us the responsibility. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. So this is a legislative matter, irrespective of what the Supreme Court may take up. We're going to put in law what we believe to be the case around states' rights to make this decision and the ability of individuals to travel to those states where it is legal, come to New York, and those marriages which are performed in New York and where people get married, those will be respected. That's simple. It's a 4-page bill. I mean, even a non-lawyer like me can get through it and kind of understand. It's in plain English. You could read it. You understand what we're... And this has a debate. As I said, in New York alone, 2007 was the first time I had the opportunity to vote on this. So this is well established, and people have every right to look to the Congress to make sure that their families are continue to be recognized by the United States. And so I'm not only for the rule, I'm for the bill, and I yield back.
Thank you very much, Mr. DeSaulnier. Ms. Ross.
Thank you very much, and I always like following my friend Mr. Morelli because he boils it down to what's going on. This is not a complicated bill. We're repealing a law that Congress no longer thinks is appropriate, and that, by the way, still is unconstitutional. So when I was a state legislator, we repealed unconstitutional laws all the time. So the Defense of Marriage Act passed. The Supreme Court found that it was unconstitutional. Congress can repeal any law that it wants to repeal. Right now, we're repealing an unconstitutional law. Kind of our job to admit that the law that was passed was found to be unconstitutional. Our job to recognize where this country is on marriage equality right now. Simple. Simple. And the rest of this bill just makes it clear that we have the right to travel and that full faith and credit covers these marriages. Simple. I mean, state legislators do this all the time. This is not, maybe we're making it more complicated. But what we are doing is we're sticking up for our people. We're sticking up for marriage. We're protecting marriages that already exist. We're recognizing that people have the right to live their lives with people they love. And we're rejecting hate. Simple. Simple. So I support the rule. I support the underlying bill, and I yield back.
Thank you very much, Mr. DeGoose. I think everybody's asked a question. Let me just say, in conclusion, I want to thank you both for coming. And I just want to just say one thing. I think we all agree that inflation is a big deal. We're all worried about gas prices. We all hear directly from our constituents. We're worried about the war in Ukraine. We're worried about a lot of things. But to somehow use those issues as a way to kind of diminish the importance of two of the matters that we talked about here today, I think is wrong. I mean, we are seeing on the previous bill the impact of the Supreme Court decision that is cruel. It is absolutely cruel. Read today's New York Times. How the unintended consequences, I don't even know if they were intended or unintended, but the consequences of that decision, the impact it's having on other surgical procedures that women are trying to deal with. And as Mr. Cicilline pointed out, you know, for gay couples in this country, I mean, the possibility that their marriage might be threatened or dissolved, you know, or made irrelevant by a Supreme Court, you know, is hard to even believe that it would happen in this country. And so, yeah, I mean, that's what we have to walk and chew gum at the same time. We have to deal with these economic issues, but let's not diminish the anxiety of people in this country right now, gay couples who are married, you know, who read Clarence Thomas's concurring opinion, also saw how he and Justice Alito voted on the Obergefell case originally. I mean, this is a serious matter and ought to be taken seriously. So I hope that that rather than just deflecting and saying, "Hey, look over here, let's not talk about this," we understand that for a lot of people in this country, a lot of our constituents, all of our constituents, these are important matters. So thank you very much. No other questions. You're free to go.